Nevertheless, marijuana use, possession, and trafficking remain criminal offenses. The federal statutes are found at 21 United States Code, sections 841 to 865. This is Part D of the Controlled Substances Act. The Ohio statutes are found at Ohio Revised Code, Chapter 2925, Drug Offenses. Beginning in 1996, however, states began legalizing medical marijuana. California in 1996, Alaska, District of Columbia, Oregon, and Washington in 1998, Maine in 1999, Colorado, Hawaii, and Nevada in 2000, Maryland 2003, Montana and Vermont 2004, Rhode Island 2006, New Mexico 2007, Michigan 2008, New Jersey 2009, Arizona 2010, Delaware 2011, Connecticut 2012, Massachusetts and New Hampshire 2013, Illinois, Minnesota, and New York 2014, Arkansas, Florida, Louisiana, North Dakota, Ohio, and Pennsylvania in 2016. If one includes cannabidiol types of medical marijuana, then the following states may also be added to this list: Wisconsin in 2013, Alabama, Florida, Iowa, Kentucky, Mississippi, Missouri, North Carolina, South Carolina, Tennessee, and Utah in 2014, and Georgia, Oklahoma, Texas, Virginia, and Wyoming in 2015. Cannabidiol, or CBD, is a type of cannabinoid in the marijuana plant that has shown promise in treating epilepsy. It lacks the psychoactive effects of tetrahydrocannabinol, or THC. Cannabidiol is also called Charlotte's Web oil, or CBD oil. Going further, 9 jurisdictions have legalized non-medical recreational marijuana use: Colorado and Washington in 2012, Alaska, Oregon, and the District of Columbia in 2014, and California, Maine, Massachusetts, and Nevada in 2016. Despite the states that have legalized marijuana in one way or another, marijuana use, possession, and trafficking remain federal crimes. The current federal marijuana law enforcement policy is found in 3 memoranda authored by Deputy Attorneys General of the U.S. Department of Justice: the Ogden Memo, the First Cole Memo, and the Second Cole Memo. The Ogden Memo. Eric Holder became U.S. Attorney General in February 2009. At this time, 16 jurisdictions had medical marijuana laws. The Ogden Memo came out on October 29, 2009. In this context, the Ogden Memo was intended to provide guidance to U.S. attorneys regarding medical marijuana legalization. The Ogden Memo advised that it would be an inefficient use of federal law enforcement resources to prosecute patients and caregivers involved in state-sanctioned medical marijuana activities. The Ogden Memo also stated, however, that it would be an efficient use of federal law enforcement resources where marijuana activities, medical or otherwise, implicated the following 7 areas. 1. Unlawful possession or unlawful use of firearms. 2. Violence. 3. Sales to minors. 4. Financial and marketing activities inconsistent with the terms, conditions, or purposes of state law, including evidence of money laundering activity and or financial gains or excessive amounts of cash inconsistent with the purported compliance with state or local law. 5. Amounts of marijuana inconsistent with purported compliance with state or local law. 6. Illegal possession or sale of other controlled substances. Or 7. Ties to other criminal enterprises. Close quote. The First Cole Memo came out on June 29, 2011. At this time, 18 jurisdictions had medical marijuana laws. The First Cole Memo reaffirmed the guidance contained in the Ogden Memo. It also advised that large-scale marijuana growers would remain a federal law enforcement priority, even if such growers claimed to be cultivating medical marijuana. The Second Cole Memo came out on August 29, 2013. At this time, 21 jurisdictions had medical marijuana laws. The Second Cole Memo updated the guidance of the first 2 memoranda. Quote, in light of state ballot initiatives that legalize under state law the possession of small amounts of marijuana and provide for the regulation of marijuana production, processing, and sale. The second Cole Memo also updated the federal enforcement priorities outlined in the Ogden Memo as follows. Quote, 1. Preventing the distribution of marijuana to minors. 2. Preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, and cartels. 3. Preventing the diversion of marijuana from states where it is legal under state law in some form to other states. 4. Preventing state-authorized marijuana activity from being used as a cover or pretext for the trafficking of other illegal drugs or other illegal activity. 5. Preventing violence and the use of firearms in the cultivation and distribution of marijuana. 6. Preventing drugged driving and the exacerbation of other adverse public health consequences associated with marijuana use. 7. Preventing growing marijuana on public lands and the attendant public safety and environmental dangers posed by marijuana production on public lands. And 8. Preventing marijuana possession or use on federal property. Close quote. The second Cole Memo went on to advise that, so long as 1. The marijuana legalizing states maintain, quote, strong and effective regulatory and enforcement systems to control the cultivation, distribution, sale, and possession of marijuana, close quote, and 2, the marijuana activity did not touch upon any of the 8 enforcement priorities, then federal law enforcement officials would deem marijuana enforcement an inefficient use of its resources and leave regulation and criminal enforcement to state and local authorities. Loretta Lynch became U.S. Attorney General in April 2015. To date, her administration has not taken any action regarding the Ogden and Cole memos. Therefore, these memos remain in effect. In fact, she was copied on the second Cole memo in her capacity as U.S. Attorney for the Eastern District of New York and chair of the Attorney General's Advisory Council. It appears then that she endorsed the second Cole memo. So what do all of these memos mean? I think 3 things. First, as long as state medical marijuana activities stay out of the 8 enforcement priorities, federal prosecutors will leave medical marijuana participants alone. This amounts to passive permission for people to engage in medical marijuana activities with reduced fear of federal criminal liability. In other words, these memos say that the feds have chosen not to prosecute medical marijuana activities, but they reserve the right to do so. Second, these memos do not provide a legal defense. If a federal prosecutor decides to charge someone with a marijuana-related crime, these memos provide no legal cover. So, a U.S. attorney could decide to prosecute medical marijuana activities. There are 93 U.S. attorneys. Ohio has 2. I do not believe that the current Ohio U.S. attorneys are prosecuting medical marijuana activities. However, because the presidency will switch from Democrat to Republican in 2017, there will almost certainly be new U.S. attorneys appointed in Ohio and across the country. These new U.S. attorneys could decide to prosecute medical marijuana activities. Third and finally, these memos could be modified or rescinded by subsequent attorneys general. So the memo's policies and guidance lack the permanence and predictability of a statute. Donald Trump won the presidential election, and he will appoint a new U.S. Attorney General. As I'm recording this, the new Attorney General has not been identified. In any event, whoever becomes the new U.S. Attorney General could dramatically change federal marijuana policy. But as of now, the 3 memos are the federal law enforcement policy. One more point on federal law. There's a 2002 Ninth Circuit case called Conant v. Walters that held that, under the free speech clause of the First Amendment, the government may not prohibit a physician to recommend medical marijuana to a patient. The U.S. Supreme Court declined to hear this case. Also, under state and federal statutes, one may not prescribe medical marijuana. This is why the state medical marijuana statutes use the word recommend and do not use the word prescribe.